Yo, welcome everybody to In God We Trust Academy podcast. Hope everybody's having a great and beautiful day, man. Don't forget to like, share, and subscribe with us. Drop some ones if you're locked in with us for the day. Got something that just want to talk to you guys about. Don't forget we got work sessions today at 6 p.m. Central Time as well. A lot going on around here, but we definitely going to make it happen as always, man. Shout out to the real out there, though. Those who don't give up. Always a beautiful blessing. Where y'all tuning in from, though? Let me know. You can never get an invite or response anymore. I had one bad day. Now, I don't be knowing what's going on with this. I actually been noticing I've been being blackballed a lot, to be honest with you, or shadow banned, as you could say. I can just tell. That's the reason why, like, you will see me go live like I am now, and then sometimes you'll just see me just go, like, use my phone. I promise there's a difference in results of who they contact and things. It's kind of weird. Oh, okay. Yeah, man, I really know what they be on, man. But let's lock it in, guys. Don't forget, October the 25th, we got a special class for you guys, paid in full. Now, before you ask, yes, you can use this on any type of bill you want to. You just got to make sure that you fully follow the procedure and process itself according to the statutes and laws, right? And so, yeah, you are definitely able to get into that class. October the 25th is where I literally took a $25 money order and went and forced a couple of laws and disputed a form of a debt and walked away free and clear with my title to my car and everything, and just literally settled everything out of court. You can also do the same exact thing. And what's going to make this even great is that you have experience from me, and I've learned way more than I was at that particular time, that I could have just made the situation way easier on me. But either way it goes, we still won. And as you can see, the proof is here on the screen for those of you that are on YouTube, Facebook, Twitch, and things like that. TikTok, sorry, y'all can't see it, but hey, you can hear. But yeah, so this is the opportunity for you. We do have a VIP section and a regular tier. So just go to InGodWeTrustAcademy.com right now. InGodWeTrustAcademy.com. Okay. There's a lot of things going on there. Don't forget about our MNRP raffle ticket giveaway, where we're going to be giving away a 2026 Toyota Camry on February the 21st, guys. Here in Huntsville, Alabama. Someone is going to win that and a few cash prizes as well. So as always, guys, we give thanks for your participation for that. It's $10 a donation. If you want, you get 2 tickets. You automatically get an ebook that's going to come with it about helping you, well, fix your credit. And also, if you buy 10, you get a free work session class of your choice from our website. Alrighty. So you're more than welcome to check us out, guys. Check us out. All right, so I just wanted to talk to you guys about a few things. But before we get in, man, I'll give thanks to you guys for your participation. Again, that's what makes this all so well and possible. So I just appreciate you. And thanks to the Most High for everything that has taken place up until this very moment. And we also, everything that you hear from this point on is for educational, religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor, as it is just my religious duty to speak my religious truth and experiences here with you guys today. So with that being said, let's talk about it. There's a lot of hype about gold bonds. Let's just talk about wealth, right? Gold bonds. Do you guys know about gold bonds? What do you know about gold bonds? Because a lot of you guys go about these gold bonds in a wrong manner, right? You go about it in the wrong way. And the way that you should deal with this particular situation is, well, you got to understand, first and foremost, how gold is used in the United States. Okay? How is gold being used in the United States? And the first thing you need to understand that right now, gold is up to about $3,800 and maybe a little more. Sometimes 30, I think it went up 39, dropped down a little bit more, but it goes back and forth between there. But anyway, $3,800 is what it's going to cost you for an ounce of gold, pure gold. All right. Coin minted by the United States. That's what it's going to cost you. Right. So now, but here's the thing, though. That particular coin is only good for one thing and one thing only if you're going to use it. Because if you use it in commerce, it's going to be $50. So that means that if you had a particular gold coin right now that you just purchased for $3,800, it's only going good to use in purchase of $50. So now you're looking at Federal Reserve notes and gold and the intrinsic value of gold. Gold is going to continue to go up. So what you got the ability to do is leverage it, right? So now you create a gold bond. All right. And you can create this particular gold bond, and this gold bond, what you create, you're going to establish the intrinsic value of the actual gold coin. We're not dealing with the commerce value of the face value of it. And the face value of it is $50. So we're not dealing with that. We're dealing with the intrinsic value of it. So we're never going to put this into circulation. But however, we can leverage it with banks, though, okay, by creating this particular bond and making it an asset within your trust, which is what I prefer to do. Way, way easier if we do it in that manner, right? So when it comes to a gold bond, it is a lawful private contract, guys, and a financial instrument secured by physical gold. So you actually have to have the gold. It's not a myth like where you're creating a gold bond backed off some form of something that's in the treasury. That's not what it is. Do you have gold yourself? Okay. And this establishes a lawful debt obligation between the parties, which is the issuer and the bondholder. Specifies a fixed or floating value based on the market price of gold at the time of payment. So at the time of payment, it can function as a negotiable instrument, meaning it can be transferred, assigned, or tendered for settlements of lawful debts or private agreements. Okay, so when secured with proper collateral and perfected through a UCC-1 filing, it becomes a recognized, enforceable private security interest. So, simple formula is gold bond equals contract plus gold as the collateral, and it could be a negotiable instrument plus security interest. It operates lawfully under common law contracts, as well as especially the Article 3 and Article 9. It's also constitutional lawful money principles as well, and it has international recognition of gold as money of intrinsic value. The nature of gold bond in law and commerce is a contract is a promise or set of promises for a breach of which the law gives a remedy. So the gold bond is a private contract between the issuer, which could be your trust, and the bondholder, which is you, okay, or your assignee, and it states the obligation, rights, and remedies clearly, okay? So it is backed by intrinsic value, not the face value, but the actual intrinsic value. So unlike fiat currency, which is Federal Reserve note, the cash that you walk around today, okay, this this particular is specific quantity of physical gold. So the gold bond is secured by physical gold. Okay. Your cash dollar is not. Okay. Now, also, you can do a certificate of ownership specifying the gold details and a UCC1 financing statement perfecting your claim if must need to be, and as if it's being used into some type of transaction, financial transaction. So you got to remember, no state, it didn't say that the federal government couldn't, okay? So y'all have to understand what y'all be saying. It says no state can make anything but gold or silver coin a legal tender in payment of debts. It didn't say that Congress couldn't. It just said the state can't, okay? That's it. So that's the reason why the states have, to this day, just like I think it was Texas, I think also Florida, implemented gold back into their currency. That's the only thing they can do. They cannot implement and create any form of paper currency at all. None whatsoever. Hope you guys understand that part. Okay, so now it is a negotiable instrument also. So a negotiable instrument is an unconditional promise or order to pay a fixed amount money with or with interest that is payable to the bearer or to the order. So the gold bond is drafted to meet these requirements. It's also transferable and assignable. So it allows you to shop to lenders or tender it to settle obligations, guys. You can do it. Got to know how to use it. Arkansas did too? Okay, that's what's up. I didn't know Arkansas did. So under Article 9, you can perfect the claim of the gold collateral using the UCC upon default or assignment. The holder, the secure party, enforces the rights to the collateral. So after the default, a secure party has the right provided by this part by agreement of the parties. This means lawful enforcement rights are built into the bond. It honors the right to contract privately, UCC 1-302. The effect of provision of this title may be verified by agreement. So parties can create their own contract terms, including payment in gold, assignment terms, remedies upon default, and the law protects private agreement as long as they are lawful and voluntarily. So make sure you understand that. Okay. Why should you create your own private gold bond? Well, here's the reason why. And has everything to do with, well, it's private wealth security. It protects assets inside a trust. It's backed by intrinsic value. And whatever that intrinsic value is, and in the increasing of that, it's also going to be worth that into your trust. Remember, we want things of appreciation. Gold does not depreciate. It will always appreciate, okay? The reason why it's always going to appreciate, because you're dealing with a dollar, a paper currency, that does what? Inflation. So since that's the case, that means the gold, which holds intrinsic value, will never depreciate against a dollar that is always going into inflation. So it's only smart, guys, to what? Buy gold to keep appreciating. 50 years from now, those $3,000, the gold is 3,000, it's going to be about 10,000. Maybe less than 50, probably 20 years. Right? It'll be worth that $50 gold coin that you hold that's an ounce is going to definitely be worth really. It's going to be up there. I guarantee you it's going to be up to about 10,000. Coin. Just watch. The way the economy going is it ain't got a choice. So it also is private negotiation power, allows you to approach private lenders or creditors with lawful payment backed by gold and not fiat. You can control over private commerce. You create, assign, and control the instrument on your terms. You got debt discharge capability, tender the bond to settle lawful debts under private contract. You can also use it for inheritance and estate planning. Use the bond to secure wealth for future generations. And you can build systems for your family, students, or clients, right? Totally up to you. It is lawful, tangible, and it's considered to be private wealth. It's not a theory. It's not dependent on third-party banking systems at all, right? So always buy things that appreciate. But you got to understand this though. And a lot of you guys go out here and you try to create this bond in the wrong way. Take the gold that you go, invest in gold. I don't care if it's a tenth of a gold coin, right? Whatever. You just go and get these things and make sure that you buy gold bars, whatever. All of these things hold intrinsic value and it's going to literally generate and create more wealth for you in the end, right? So just make sure. Gold holds value outside of the fiat system, and creating your own bond means your wealth exists outside inflation, outside bank failures, and outside debt cycles. That's what you want to happen. Contract law, right? In self-governance, a contract is a promise or a set of promises for breach of which state law gives remedy. So that bond can be just that for you. Just that. It can secure a negotiation tool for private lenders. So a security interest is enforceable against the debtor and third parties with respect to the collateral if the debtor has rights in the collateral or power to transfer rights in collateral to a secured party. Once you create and perfect your bond, lenders recognize your security interest. You negotiate from strength, not from need. You can shop your bond to private wealth officers, lenders, or deal makers as a lawful collateral. Why? Because that bond is even considered an asset. And the asset that backs it up is literally the collateral, which is the gold itself. And we're using it based upon its intrinsic value. And that's what the bond is going to state, and that's how the bond is going to be governed. So anytime you decide to use that bond, you can say this bond cures in 50 years. And then they can call upon that particular bond. It's simple, guys. You can really do stuff like this to use it to pay off mortgages. All right. So if you got a 30-year mortgage or something of that nature in plan, you got a couple gold coins, and based upon intrinsic value or whatever, I mean, it could be a car note, whatever. I'm just saying you could definitely use these type of methods to be able to set off debt in this particular way. All right. Just so you know. But you got to just make sure that the other party understands and y'all can come to an agreement. It definitely can be done. All right. So if tender an obligation to pay an instrument is made to a person entitled to enforce the instrument, the tender is refused. There is discharge to the extent of the amount of tender. So tendering your bond is a lawful payment. If a creditor refuses, the obligation is discharged to the extent of the value tendered. You can also use that. So you preserve your rights, create a record of settlement, and establish lawful discharge. So remember, you can use it for discharge, generational wealth, just helping you expand your trust portfolio. Okay? So if you guys out there that has these bonds, that has these different things, then use the intrinsic value. Gold, dollar coins count? No, they're not, that's not real actual gold. They just is plated. I'm talking about real gold, pure, minted. Because that you can go trade $1 for that gold. There you can't go. And this is the see, now y'all got to understand why you can't go to the Federal Reserve and give them a $50 bill and they give you a 1 ounce gold coin. They're not going to do that because they understand their dollar is not even, their $50 bill is not even worth that gold coin in intrinsic value. They know that. That's the reason why they are continuing to mint these gold coins and stuff like that. And it goes out into these, like Apex and stuff like that. You know what I'm saying? That, these people that mint gold and sell gold coins and corporations that does those type of things. Other than that, they're not going to do that. And you got to know that. So now that you do know that, that means that you got to know how to leverage the dollar into buying things that appreciate. That's what you got to do. So when you draft a gold bond agreement, you got to have the face value in gold collateral, maturity date and payment terms, collateralization and security interest, event of default and remedies. Make sure you have an assignment clause, a governing law clause. Okay? Make sure that you have those type of things, right? Gold is recognized as a lawful tender in private agreements as well. And that just means any party that you're dealing with can come to an agreement with you to deal with that. So after you do that, you create what you call a certificate of ownership, declaration of ownership. And once you create the certificate of ownership to show that, now that shows that you can what? You got the right to assign it to anybody that you may want to. So, absolutely. Silver is the same way, guys. Silver has intrinsic value too. So you need to understand you can do silver bonds the same way. Operate on the intrinsic value side of it instead of the face value side, right? So it's just certain things that you're going to be able to do when operating like this. So creating wealth is literally getting things that appreciate, learning to get into compound interest, but also knowing just to create a gold bond. So those of you that are interested in this, what I have for you guys is this particular gold bond class that I've done, and I'm going to give it to you guys at a net price today. So this is the class that'll teach you exactly what to do with your gold coins, even silver coins, okay? So yes, it matters with your gold and silver coins that you have minted. All right. So let's see what kind of price we can get you guys today. Let's see how much the gold bond is on the website. Gold bond blueprint class. Dun, 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 dun. It says 150. I tell you what. Give me $80 even. $80 even. Okay. $80 even. I think that's pretty good. $80 even. So you guys are going to be able to get that. All you need to do is do this one special thing. You got to follow the order here. Okay. And yes, you can do this. There's people who have already gotten a remedy for doing this type of thing. I mean, it's just really law and it's contract. You got the right to create the contract. You got the right to operate on the intrinsic value side, just like any other people are here doing. So you got the right to do that. So do it. But learn to do it the right way. Not up you on fathoming, you know, you're thinking of some gold that might be in Fort Worth or something like that. Like, no, that's not nothing to do with you specifically. Okay? You got to understand that part. So know that. And right now, especially. So what I'm going to say is this. $80. That's what we're going to do it for. And it will be done at discount. Okay? I don't even know if she's watching it here, but I'm pretty sure. So it'll start at 3 o'clock. 3 o'clock is when it's going to start. $80. All right. Also today, everything is going to be 25% off. Yesterday was half off. Yeah, some of y'all missed that. So it's on my site, yes. InGodWeTrustAcademy.com. So go there. All right. So now that we talked about that, let's talk about this other special thing that I did for someone a while back. And I was like, let me share this today because I haven't shared it, and you can learn some things. You can learn some things. So this gold bond, guys, like I say, it has a lot in here. It shows you how to do it, what to do, what not to do. It fully explains everything to you guys so you can see that. It's about 84 pages long. A lot of great information. Even shows you how to file the UCC. statement as well for it. If you do any assignment, you can do that. And like I said, it's all in here. And it also comes with, if I'm not mistaken, yeah. So it has the mastering gold bond form. So it comes with this as well. So you're getting two forms of ebook. One is fully explaining everything. The other one shows how you get the gold back private bond agreement, fully there for you. Certificate of ownership showing you how to specifically do that, and how to literally file the UCC1 statement as well. And if you want to do an assignment of security interest, it's also there. So everything that you need to be fully equipped with, and how to do a UCC3 when you make that assignment and transfer it. So you can keep up with that. Notice of tender and payment settlement. So you can use your gold bond to do that as well, to make an offer. All of it's there. So again, $80 can't beat that. It's really about a $500-$600 class, and really it's $150. So really, even that's a good deal on the website. But I'm gonna give it to you guys at $80 today, just out of showing some love and hoping you guys get to the same place. All right. So a while back, I had a situation to where I was dealing with someone that needed me to get rid of a claim for them, right to bear arms situation. And in this right to bear arms situation, I think that people don't understand what the right to bear arms is, and that is a right that is always retained by the people. And remember, it always has to be in your defense. So what I did was an abatement action, and this was probably hanging over their head for a little bit, but they had some other things going on. They were also locked up. So there were certain things that I had to come through and be able to do to make sure that everything works the way it's properly supposed to work for them. So I'm going to share with you guys today a notice of abatement of action for lack of jurisdiction, impairment of constitutional rights under the U.S. and Texas Constitution, violation of due process, and also malicious prosecution. So you guys got to listen very carefully to what I'm about to say to you about your rights. And the gun rights is a real serious thing, because your sons, your children are carrying around and walking around with guns, with switches and with sticks, as they call them, with on the end, extendo clips and all of this type of stuff. They in love with it. They love showing it in videos. They doing a lot of different things, and police are very aware and see these children with those. So they might be attempted to get pulled over if the police know someone personally and all of that, and just be looking for a gun just so they can charge you, because they're watching your children on social media and other places. Right. You don't think they're watching? They're watching, I promise. And they prey on those type of situations because it's easy, especially when they don't like you. Maybe you're kind or whatever, but don't make the opportunity for them easy to do. So that is the reason why I say you need to know your rights as parents teaching your children. I keep saying you're letting them go out there not fully prepared for the world, and we have to stop doing that. We have to fully be aware of all of our situations and everything that we are inclined to be into. So you are in the United States of America at this point in time. There are inalienable rights that are fully protected by the Constitution. The Constitution does not grant right; it protects those rights. As it is stated in Amendment 9, that there are the enumeration of your rights as well, right? These are rights that are not literally mentioned or written down in the Constitution, but are still protected and retained by the people. And if the people never exercise those rights, that's the situation. You don't exercise them because you probably don't even know that you have it, because there's some type of statutory law that looks like it contradicts you even having that right. But here's the thing. It's your duty to show that your rights and your right, okay, and de jure itself literally, okay, supersedes the statutory, because the statutory causes a conflict of interest and a right that's fully protected by the Constitution. And they swore oaths to protect that. You have to know how to use that. So in this situation, we did a notice of abatement. Okay. We did put this in, and also a motion to dismiss for lack of jurisdiction. So the notice of abatement is hereby served. You'll put them to the court and all interest parties in the matter of whatever case. The purpose of this abatement is to challenge the jurisdiction of the court, protecting all inalienable rights granted by God and recognized by the U.S. Constitution and the Texas Constitution, and distinguishing between the natural person, John A. Stowe, and the legal entity, John A. Stowe. This notice further addresses violation of due process and malicious prosecution. So, John A. Stowe is a natural person created by God, endowed with inalienable rights that cannot be abridged, denied, or diminished by any government or legal entity. Your rights are protected under the U.S. Constitution and or the state constitution as well, which recognizes the supremacy of individual liberty and personal autonomy. So, Hale versus Hinkle recognizes that a natural person's rights are inherent and cannot be diminished by statutes. Murdoch versus Pennsylvania, the state may not impose a charge for enjoyment of a right granted by the federal Constitution. So, protected under the Texas Constitution, and this is also in your Constitution, but I did it for this individual in Texas. So, natural rights. The Texas Constitution reaffirms the inalienable rights of individuals under Article 1, Section 2, which states all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. So this recognizes the supreme authority of the people, all right? And any statutory law that infringes on this power is void. So John A. Stowe, natural person, stands on his inherent authority granted by God and Constitution. The Constitution says the right to bear arms under both U.S. and Texas is this. Every citizen, okay, this is what Texas state, Article 123, shall have the right to keep and bear. So keep and bear. Keep and bear arms in the lawful defense. Listen to the words that's being said. Lawful defense of himself or the state. Okay? John H. Doe bearing arms was in lawful defense of himself and is therefore protected under the U.S. Constitution and the Texas Constitution. There was no unlawful use of the arms, nor was there an injured party making his arrest unconstitutional. So what this means is they would literally have to prove, just because you got the guns don't mean they can charge you. It could be yours, it could be on your person or anything like that. It does not matter. They can't write the statutory laws does not apply to you in that way because you have the right to bear arms. They would have to prove willful intent for you to go out there to make war and cause harm. But you just having the guns for yourself for your defense, they can't do anything about that. Nothing. And you can get a case dismissed every single time if you know how to fully present it. Got to know this though. Okay? So now, District of Columbia versus Heller recognizes the individual right to possess firearms for self-defense. Also, McDonald versus the City of Chicago applies the Second Amendment to the states. So, State versus Cellular in the state of Texas, the Texas Court of Criminal Appeals held that an individual's right to bear arms for self-defense is protected under the U.S. and Texas Constitution. Okay? That's it. All you have to do is make them prove. Okay, so do a motions of discovery. Motions of discovery is your tool for them to show proof of evidence that they can prove that you were not bearing arms in defense. They would have to prove that you were in a way of using to cause harm or making war against another. And they can't prove that if you just got it on you. So they would literally have to have someone calling saying you threatened their life and all this type of stuff, and they got proof of that. And you're on your way, or there's some type of text messages, emails, or something saying that you're going to come do something to somebody. Now you're bearing arms with the intent to cause harm, not in defense. They can charge you. There's a difference. Now, if you're going to be operating as a security in profession, then yes, you're going to have to get some license and all kind of other stuff. Absolutely. Because now it's not in defense. It's basically now for your job. And we need to know that you're licensed to carry, to operate, and do your job as a security. Two different things, guys. Got to know that, right? So, violation of due process for failure to see a magistrate. So, under the U.S. Constitution, right to due process is protected by the 5th and 14th Amendment. The 14th Amendment controls the actual state. The 5th deals with the federal. So, no citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or any manner disfranchised except by due course of law of the land. The state failure to present, the state failure to present the defendant to a magistrate is a clear violation of due process rights guaranteed under both constitutions. And like I keep telling y'all, they have to take you to the magistrate first to make sure that they have enough evidence in order to charge you. By them just processing you and doing all of that stuff first and then charging you. And then if they dismiss the case, that is a malicious prosecution because, again, you knew you didn't have enough freaking evidence in the first place. So you maliciously charged me with something that you didn't have it. And that's the reason why I say they will put you in jail first, fingerprint you, process you as if you are already guilty, and then as soon as you go to court, they make you sign these papers as if you what? In acceptance of the charges, etc. That's what they do right before you start court. And you ain't even aware they were supposed to make you go to the magistrate. They're doing it as if you had already seen the magistrate, and you haven't. And the one who arrests you is the one who's supposed to take you to the magistrate. That's another thing. Okay? So the case law says this. Gerstein versus Pug requires prompt judicial determination of probable cause after an arrest. So they have to give it. County of Riverside versus McLaughlin. Delays of more than 48 hours without seeing a magistrate are unconstitutional as well. Ex parte Garcia. Here, a delay in presenting an arrest individual to a magistrate violates both U.S. and Texas Constitution. What's the delay? They should be able to see that individual immediately. That's the reason why the courts is always supposed to be open. It's always supposed to be a magistrate on hand. I don't care, 24/7. Because what? Liberty demands for you to be free immediately. Not because you know why? No time is promised to any man. No time is promised to anybody. You could die at any second, any minute, and then let's just say something happens to you in their custody, and now you just lost your life based upon the violations of due process, etc. Due process. Yeah, it demands you to be free immediately. That's why justice is swift, right? So now, when John H. Doe was arrested under a vague or overly broad statute, the law would be unconstitutional under the void of vagueness doctrine. This principle also applies under Texas Constitution, which requires law to provide clear guidance. Papa Cristo versus City of Jacksonville struck down a law for being unconstitutionally vague, and Graham versus City of Rockford held that laws must provide a reasonable opportunity to understand what is prohibited. So you got Long versus State. This is an appeal court. So Texas Court of Criminal Appeals struck down a statute for vagueness, applying the same legal principles found in the U.S. Constitution. So John H. Doe bearing of arms was lawful for lawful self-defense, a defense that is recognized by both constitutions, federal and state. Texas law specifically allows for self-defense under Penal Code, Section 9.31, which mirrors the necessity defense. Okay, so United States versus Bailey allows the necessity defense when actions are taken to prevent imminent harm. So you're trying to prevent any harm. That's the reason why you're holding it. It's not to make war. Statutory laws that infringe upon constitutional rights must meet strict scrutiny under both the U.S. and Texas Constitution. The government must demonstrate a compelling interest that the law is narrowly tailored to meet the interest without infringing on the right to bear arms. So, Sherbert versus Verner established that laws burdening fundamental rights must meet strict scrutiny. So them trying to make you go get some license for the right to bear arms, and let's say you just you're an indigent person, you don't have money like that, so you could be poor, but you still got a gun and some bullets, and you got the right to bear arms in protection of yourself. They can't burden you saying with the right that already exists, that saying that you have to go get a license and pay a fee for it. That turns it into a privilege and it takes away a right. You cannot let that happen. Murdoch versus Pennsylvania as well. So think about that. All right. When it comes to Albright versus Oliver, recognize a claim of malicious prosecution when Fourth Amendment rights are violated. So it says John H. Doe is being subjected to malicious prosecution for exercising his constitutional rights to bear arms. Under both the U.S. and Texas Constitution, malicious prosecution is prohibited when legal proceedings are initiated without probable cause. There is no probable cause here. So why are we here being charged for gun charges? There's no reason. And we just took away the subject matter. So detention without being presented to a magistrate violates his right to a speedy trial under the Sixth Amendment and Article 1, Section 10, Texas Constitution, which states in all criminal prosecution, the accused shall have a speedy public trial by an impartial jury. John H. Doe can petition for a writ of habeas corpus to secure his immediate release. Now, here's the thing. If the city arrests you, and the city is always going to do it by, it's always by way of information, because it's by way of information from an officer. It's never by way of indictment. And it has to be by a grand jury indictment if it's going to be considered a felony in a criminal situation, so that you're going to deal with somebody's liberties and take those liberties away. So that's the reason why you see, I think it's named Tanawa. Maybe I didn't say it right. And the other lady, Stacy or whatever, they're going away. They're going to all these different places, speaking on these things about how these cities and municipal courts are literally using, they're violating due process by doing, by way of information, by doing criminal, what do you call it? By criminal prosecutions by way of information. That's a violation of the law. You can't do that. I totally agree. Yeah. So we got to change the narrative of that, right? So now, Barker versus Wingo, a delay in trial violates the right to a speedy trial. Ex parte, Delaney is recognized the right to petition for habeas corpus for unlawful detention. So there is no injured party in the case, and under Texas law, the absence of harm or injury weakens the state's claim. John H. Doe actions have caused no harm, injury, or threat, making the arrest unconstitutional. So Shenick versus the United States held that conduct that does not create a clear and present danger is protected. In light of the above assertions, including violation of John H. Doe's constitutional rights under the 2nd, 5th, 6th, and 4th Amendment of the U.S. Constitution and relevant sections of the Texas Constitution, lack of jurisdiction, and malice prosecution, I hereby demand all things in the proceedings in this case to be abated. All right? There you go. And that's how you do. And literally, the individual had did some other stuff. They were into, I don't know, they had drugs or whatever, but I definitely got the gun charges dismissed. I didn't really start dealing with the other situation for them, but all the gun charges were thrown out and dismissed easily. You guys got to know. And people were like, oh, yeah, it's different in New York. No, it's not. Because all you got to do is take any of those public servants in New York. You can take them and then you can sue them according to 18 U.S.C. 242. Well, not sue them. You can have them criminally prosecuted under 18 U.S.C. 242 because that's for criminal prosecution. And 18 U.S.C. 241 because they are depriving you of your rights using color of law. And you can sue them according to 42 U.S.C. 1983 using the 14th Amendment as well. So 14 U.S.C. 1983 is the cause of action. And we're going to sue them according to the violations of the 14th Amendment, which is due process that is still fully protected. So that's how you sue the state and its public actors, right? That's how you do that. New York. It's very simple. You can do it. You just got to stop being scared and afraid because they act like they're above the law and they're not. And I know how New York roll and do a certain couple other things. That's just like even when I saw what's his name go to jail, it was stupid. Like I remember Lil Wayne going to jail. That was stupid. That was stupid. But over a gun or whoever else, and it's just, you know, you're not supposed to if you know what's right. But y'all let them trample on you over you with statutory laws. So, guys, that's just a few things that I wanted to share with you guys. Remember, when it comes to the gold bond, guys, always know that you need to buy your own gold and create the gold bond to it in intrinsic value in order to leverage and use it with banks. Okay, you can do that, and that is for $80 right now on InGodWeTrustAcademy.com. So do give us time, give us at 3 o'clock, and that will be up for you guys. Also, we got 25% off on everything except for the upcoming class and any consultation. So there is 25% off. Remember, we doing trust setup. It's half off. It was $1,200. It's $600 now. So if you want your trust set up with us, we'll fully do that with you as well. And don't forget about the paid in full class coming up October 25th, 2025 as well. Okay, so these are great classes, great things going on. And we have the Lawful Money class coming in December. I picked December 19th. So that will be the day, December 19th, or maybe the 13th, 16th, somewhere in the middle. It'll be right the week before. So it'll be like a week before y'all fall into Christmas is what I want to do. We'll do that. And also the 1st of January, we're going to have the criminal law course. It's going to be 30 days. We'll do it on weekdays. So it'll fall over into February. Probably be done after like my birthday or something. I think the 13th is what I had. But we're going to do that as well. If you want to be able to sign up for that, that's going to be available to you. So it's going to be nice. Okay, December 19th, I'm going to do it here in Alabama. So I always do, at the end of the year, I always do a conference here in Alabama to allow my peers, people where I'm from, in the state of Alabama and stuff like that, to have an opportunity, because I usually travel everywhere to do other things, which I have. We went to Destin, we went to Houston, and we also did one in Seattle this year, kind of like back to back to back to back. So I try to give people in the South around Georgia area, Mississippi, Tennessee, and stuff like that, the chance to operate and come here to vibe with us. And if you guys don't mind taking a flight or drive, then come rock with us. More than welcome. We're going to do a great job in giving that class to you guys as well, and to give you a true understanding what it means and how to operate. It is a administrative process. It's not a litigation process, just so you guys do understand that. So I just want to put that out there, man, to you guys. Appreciate you guys. Don't forget, 6 p.m. Central Time, be back right here. Okay, we got to finish up our class, our work session. It is public safety versus personal liberty, so you can truly understand how they use public safety as an overreach in government over into your rights, and how they try to use that. So what do you need to do in order to, object and reflect those things and to protect and preserve your rights? Again, peace. We up out of here, man. Don't forget about our ambassador program. If you want to be an ambassador for us, and yes, we paying. So come check us out, man. Send me a text, or not a text, but a DM or whatever, and I'll make sure that you get a chance. Get your application in. I'm about to start looking at those and getting some people rolling in so we can get that going as well. So I appreciate y'all. I'm not going to do the mentorship program until next year. It's just a lot I got to come up with to do that. So I'll see y'all at 6 p.m. Central Time, man. Y'all have a great one. I am out of here.